Okay, we are live.
All right, thank you, everyone. We are gonna go back to Amber. Post closed session.
Your slide here.
Okay, welcome back, everyone. Thanks for sticking around. Just a recap on what happened in closed session. The committee approved an award, all available funding, $3 million to New Jersey Conservation Foundation.
And I think we were muted for a second. I'm sorry.
Oh.
We weren't. We're good.
Oh, I think my mic was not.
Okay.
So just in case you missed it, in closed session, the committee approved to award all available funding, $3 million to New Jersey Conservation Foundation for an acquisition in the Medford Evesham Prairie acquisition area in Burlington County. The commission recommends a 1-year deadline to execute a grant agreement. This would bring us to November 2026. And then at that time, the applicant would be expected to align additional funding sources to match the grant and then all the other granting institution requirements. And so our immediate next step would be to draft a letter and send to the project partner and notify them of the award. Congratulations.
All right, thank you so much, Amber and Gina and the team for all your work here. Really exciting stuff. Thank you. Okay. Next up, Susan. A discussion of proposed CMP amendments for quote unquote gap app.
Oh, I wish this was gonna be as happy and exciting as.
We call them gap traditions.
We have been entertaining ourselves with names for this for many years.
I'm ready to follow over with gap.
Yeah,
But let's see what else we got. It's all right.
So, I do have some slides. I will say, when I sent this to Paul, of course, he didn't have any beautiful photos. He made it look gorgeous. It's a very dry sort of topic, but don't get distracted by the picture. Right.
No, get distracted, please.
Yeah.
What is it?
Just kidding.
The top button, yes.
Bottom button is forward, of course.
Okay, so, we have some draft amendments to the CMP that we want to review with you today. They're just draft. We're not at the point of doing a formal proposal, but it's been several years since we discussed this with this committee. We've been busy with other rule changes, and this one kind of got put on the back burner. Hasn't really created any issues in the interim. However, it is something we know that we need to address. And now that the commission has adopted what Gina likes to call package number one has been adopted, we're moving on to some of the additional pieces for, I guess, rule package 2, which we'll put together sometime in 2026. So this is one of the pieces. For some of you, this will be new because you weren't here when we discussed this previously. For some of you, it will look familiar. So the purpose of the amendment is to put into the CMP or codify an application process for a very small category of development application. There are these projects that come to us, they're proposed by non-governmental entities, so they're not public development projects, they're not proposed by towns or counties or the state, they're proposed by private entities. They come here and file an application for development. And the development itself is, for whatever reason, not subject to local review, meaning municipal or county approval procedures. They don't need any municipal or county approvals, either due to some state or federal law that preempts local review, or there's other reasons and the town simply doesn't review applications of that sort. They don't need any local permits or approvals. It's a long description, but it is a narrow category of application types. We don't see many, but we don't have a process in our rules for that. So we'll talk about that in a minute. The objectives here are to make sure that when those applications come to us, we have a clear process that's followed, that provides an opportunity for public review of the application and public comment directly to the commission. And then a final determination of consistency with the CMP, whatever the project is made by the commission. Not by the staff, not by another agency, but by the commission itself. That is the goal. So a refresher, because it's important to understand how our application procedures work right now. So that you can see the gap that we're calling and how these projects sort of fall into the gap between the current private development application process and the current public development application process. If it's a private development, not a governmental agency, they submit their application to us, the staff reviews it. If it's complete, we issue a certificate of filing, as you all know. That will note if there's any inconsistencies that we think exist with the CMP. The applicant takes that document and goes off to the town and the county to get whatever permits or approvals they need, whether it's a building permit, a septic permit, site plan or subdivision approval, zoning permit, whatever it is.
That's a new one.
And yes, well, there was a lot of rain yesterday, so,
The floor.
yeah. Anyway. Probably there. Like we're vibrant. Anyhow, that's the normal process, you know, the applicant goes to the town or the county. They get their permits or approvals, they provide whatever public notice the municipal land use law requires. They notify neighbors, they put notice in the paper. Planning board or whoever it is, you know, will accept comments. If it's a site plan or subdivision approval, so there's public participation and public notice, typically at the municipal level. And then whatever approvals are issued by the town or the county, the permit, approval, resolution, comes back to the commission for the staff to review to determine, okay, yes, the development approved by the municipality is consistent with the CMP. It's the municipality or the county that issues the approval. They're making effectively the determination that the project is consistent with the local zoning ordinance, the county development ordinance, the land use ordinance, the zoning map. And in so doing, they are also effectively making the decision that it's consistent with the CMP. The staff is only reviewing that approval to make sure there aren't any substantial issues that are raised. That nothing has changed, that everything still looks good, and we sign off on the approval and it takes effect. But it's the town or the county that are making the decision and the approval. That's for private development. That's really not an issue. That process has been going on for, here's the rest of the process, a very long time. And it works well. So when those permits or approvals for that private development project come here, as I said, we're overlooking, you know, we look at them, make sure, okay, everything's still good, and if it is, no substantial issues are raised, we'll send a letter to that effect saying, okay, no further review by the commission is required, and that approval or permit can take effect. If there is a substantial issue raised by the approval, we will send a letter to that effect and say, there's an issue, we're going to need to schedule a hearing. Hey, no, it's not good. I could only imagine what's happening over in Bedford right now. So we will schedule a hearing to review the matter formally and have the applicant discuss that substantial issue with us. Typically, we never actually get to the point of holding the hearing. We send out our letters identifying the issues. Applicants traditionally will look at that and go, okay, they've already got a plan for purchasing and redeeming their PDCs, for example. They just wait till the end of the process to do that. Lately, it's stormwater. They know they need to revise their stormwater plans, and all of that will get done prior to the need for the actual hearing being held, and the issues get resolved. We send a letter saying, okay, good, the approvals can take effect, and there's no hearing that actually occurs. On the rare occasion when a hearing is held, the applicant can choose whether they want to have that hearing held before the executive director and the staff here in this room, or they can choose if they prefer to have the hearing held at the Office of Administrative Law. That's very uncommon. I can't remember the last time it's hard to even remember the last time we had one of these hearings, much less when it went to OAL. So not common, but they are public, so members of the public can attend. If the staff is holding the hearing, it's advertised, the applicant provides notice, we open the doors, people can come in. They can provide comment to the hearing officer, which is typically the executive director. They can submit written materials for the record. We would then gather all that information and prepare a report and recommendation to the commission itself. Again, this is very rare. You've all probably never experienced one like this. But that report and recommendation for a private development application would then come before the commission itself. Just like you typically see with public projects, you'd have a resolution for a private development. And you would be taking action on that formally. And then if there's an approval or a disapproval by the commission, the county or the municipality who issued that approval would be required to either revoke it or revise it. Again, it's very uncommon, but there is that opportunity for private development projects to progress to a hearing and come before the formal commission for determination.
That's not adjudicatory. That's not an adjudicatory hearing per se, so it's not a like typical court process. That's a public hearing.
It's a staff hearing,
Right.
right? So again, it's people can come, there's notice. They can sit, stand up and speak, they can submit reports. Anybody can testify. It's not we don't qualify people, we don't say, are you an expert or any of that, it's just a public hearing. Anybody can come and say whatever they want, the applicant can come, the applicant can have his experts, they can all testify. It's all about staff shoot the record, which is the basis for the staff recommendation to the commission. Yeah.
He already called over to.
Okay.
Thank you.
It is a little distracting. So that's the private process that's currently in effect and has been for decades. The public development process you all are much more familiar with. We receive an application from a county, municipality, or the state, for example. We post that on our webpage. We have a status report for active public development applications. We post them there so that everyone is aware that they've been submitted. Applicants for major development are required to provide notice, public notice, certified mailings, notice in the newspaper. Before the staff can determine that an application is complete. Once it is complete, we will again update our webpage to say the application is ready for public comment. At the next commission meeting, and you'll see those on the agenda where people can comment directly to the commission on specific public development applications. The update will also note the deadline for submission of written comments, which we also accept. And once the comments are collected or provided directly to the commission, we then prepare our report. We'll review the application, determine whether it's consistent with the CMP, and provide a report and recommendation to the commission itself. And it'll be sent out to the applicant. Anybody who provided anyone who provided comments on the application, and any others who requested copies. In advance of the commission meeting, there is an appeal period provided for interested parties of the staff's recommendation. And once that appeal period has run its course, the commission votes, as you know, at your meetings routinely on public development applications. So there's a formal action and decision by the commission to either approve what the staff was recommended or refer the matter to the Office of Administrative Law. So those are the two procedures we have now in the rules. And then we have identified this category of applications that don't fit into either of those, fully fit into either of those procedures. They therefore fall into the gap, which is our clever term, but we're accepting others if you have other ideas. But for now, we will call. Perhaps. It's kind of
unusual, so I.
But for now, we're calling them gap applications, which means private development that does not require municipal or county permits or approvals. They may well require state permits like DEP or DOT. They probably do require some kind of state permit or approval, But the commission does not have the authority to review state permits and approvals. Pinelands Protection Act does not give us that authority. We can only review municipal and county approvals and permits. So if I'm one of these private development projects and I go off to DEP and they issue me, I don't know, a freshwater wetlands permit or something else, the commission cannot review that permit and say, okay, good, it's consistent with the CMP, we are allowing it to take effect. Cannot do that for state permits and approvals. So that leaves us with no permits or approvals to review. If we can't review the state permits and they don't receive municipal or county permits and approvals, we have an application, we issue a CF, and then there's nothing. So, for example, public utility infrastructure projects, such as, I hate to say the word, pipelines, but also other infrastructure. Typically, these projects, if they cross over municipal boundaries and involve more than one municipality, there's provision where under the land use law, they can vote with APU and seek an exemption or preemption from the need to obtain municipal or county permits and approvals. Therefore, they don't get them. That's a gap project. We've identified, originally, we thought that was really the only category we were dealing with. But over the past few years, we have identified other types of private development applications that do not apparently are either not required to obtain local permits or approvals or simply don't get them. Whether it's because the town has said we don't issue approvals for that, or whatever the reason is. Things like water supply wells, recycling facilities, privately owned cell towers on municipal property. That's a good one. A retail commercial use like McDonald's, for example, that gets built at the Garden State Parkway or Atlantic City Expressway Service Plaza. This last one was actually fairly recent legislation. Offshore wind connections to the power grid don't require, the legislation specifically says no municipal or county approvals are required for that. So there is a broader category of these gap projects than we originally, when we were first working on this rule years ago, than we originally were aware of. We thought we were writing the rule just to deal with the public utility infrastructure projects, but it turns out there are a number of other types of projects that fall into this gap. There's not many, but it does happen. So, we need to come up with a process in the rules, not just made up to handle an application from time to time, but something in the rules that specifically establishes a process for these gap applications. We were directed to do that by the Superior Court, the Appellate Division, in dealing with a couple pipeline applications from years ago when the gap was identified and the court said to the commission, you must establish a process that provides for public input and comment and results in a decision by the commission itself as to the consistency of that development with the CMP, not the staff, not BPU. The commission has to decide, which makes sense. That's how it should be. It should be the commission determining whether a project is consistent with the CMP. So that was a directive of the court. And the commission at the time in dealing with those applications came up with a process and adopted a resolution to say this is the process we're going to follow. Because obviously there was no time to amend the rules in the midst of the application process. So the resolution established the process, which is going to look very much like what we're proposing here. Which is to provide in the CMP clarity on the process for these gap applications. And the way we propose to do that is first step when an applicant submits an application for private development, whether it's major or minor development. We have this language in the proposal and some of it's in the current CMP already. We want them to tell us what other permits and approvals are you going to need from the county, from the municipality, from the state, or any federal agency. Tell us now. what approvals and permits you're going to seek. If you don't need any, we want to know them, so put that in writing as part of your application, that you are seeking a preemption from municipal and county review. Or whatever the reason is that you, the applicant, don't believe or don't intend to seek municipal or county approvals. So that's sort of at the outset, we would be asking the applicants to identify that as part of their application. Because that will help us figure out which paths do we send them down. So if the applicant says, or we know that they are proposing development that is not going to go to the county or municipality for any permits or approvals, we will then say, they're going to be subject to the same procedure I just described for public development, which means the commission is going to have the ultimate say and determination as to whether the project is consistent with the CMP. So the rule has language that will direct the applicant to those sections. I'll show you that in a minute. The other thing the rule does is clarify this very section that almost nobody ever reads in the rules. It's 4.81. It talks about coordinated permitting. It mirrors the language that's in the Pinelands Protection Act that says that other state departments and agencies and officials are not permitted to issue approvals, licenses, permits, and there's a whole long list of things for construction or disturbance of land in the Pinelands area unless it's consistent with the CMP. The wording we're added is to say that unless the commission has determined that that development is consistent with the CMP, because as written, it was just sort of, it implied that the other state agency would determine consistency with the CMP, which they don't do and wouldn't do and doesn't seem appropriate. So this is a clarification that it's the commission who makes that decision. And so the process as proposed would look like this. Application comes in the door. It is accompanied by information that may say no local approvals or permits are needed. I'm not going to be seeking any municipal or county approvals. We would say, okay, you're a GAP project then, and that would trigger the rest of the process. We would have to have some sort of new status report on our website for these types of projects. We would post on that webpage we have received, just like we do for public. We have an application, it came in the door, here's the number, here's the block and lot, here's what the proposed development is. If it's for major development, just like for the publics, the applicant would be required to provide public notice to surrounding landowners and in the newspaper. The staff would review the application to make sure it's complete and consistent with CMP. And once it's complete, on that webpage status report, we would note the dates for public comment at the next commission meeting and the deadline for submission of written comments. And once the public comment process is completed, just like for public development, the staff would write a report, make a recommendation, prepare a resolution, schedule it for action at a commission meeting. You'd see them listed on the agenda in some special section that we'll call GAP applications for now. And the commission would take action, just like you do now for public development projects, would be a resolution, review of the report. You could have a discussion, you can ask questions, look at maps, all of that would occur just as it does now. And at the end of the day, there would be a decision by the commission either to accept the recommendation of the staff, or if necessary, there's an issue, refer it to OAL for further review. I talked quickly. But
Today's question.
yes,
Okay, absolutely.
well, I was the chair.
That's.
Let me just finish my last slide, which is,
Okay.
again, we're not running down, we're not running to publish this. We haven't written the full proposal. I just wanted to bring this matter and our suggestions back to the committee for discussion today, so that we can listen to your concerns or any issues that you see, before we actually prepare the formal proposal. And again, this is not going to be done or before this committee again or full commission until sometime in 2026. So there's plenty of time for comments and questions and alternate suggestions if people have another process they think we should follow. But what I don't want to do is let this sit any longer. I wanna make sure that someday we'll get another project in the door that causes this problem. And what we don't want is for the court, I'm sorry. What we don't want is for the court to say, we told you to do that many years ago. Why haven't you done what we ordered? So
When you explain the previous slide. You mentioned the word major,
yes,
right? Because it's on there. okay.
yes, just as it is.
Did you remind me what the definition of that is? Because do we have to, do we need to change the definition?
Oh, I certainly hope not.
Okay.
That would affect us.
Well, I mean, for these projects.
Yeah, I would prefer that we do not do that. I think, yes, I could try. It's easier for residential development,
Yes.
which I think is if it's 5 or more units,
Right,
that's major development,
right.
right? If it's non-residential, then I think it's 5,000 square feet of disturbance or more
Okay,
is major. So it's gonna cover
okay.
those things. That the commission, what I don't wanna do is have small things like a little, I'm improving my little parking lot.
Yeah.
That's mine, probably
Right.
and that'll still go through the process, but they won't have to do newspaper notice or notify the neighbors. There will still be a public process, just like there is for public. There will be our webpage, which is where most people go, not the newspaper, for information about what is pending before the commission. There will still be public comment directly to the commission, so you'll have people here, providing comments to you and written comments. I'd like as much as possible to follow a process that we already have.
Yeah.
That the public is familiar with. And so. The more we tweak it to be special for this, the more I think confusing it'll be, so, anyway, that's.
I'm trying to think of the definitions and what falls in where, and I'm glad you gave us the examples, because I couldn't think of anything when I was.
Oh, yeah,
I was like, okay,
yeah.
what? Okay. And things that are coming in the future, or we haven't seen it yet, there's some data centers, for example. Right, and things like that, is that, if it's a private, well, it only.
But
It's greater than
right.
5,000.
Yes, but remember, if it's a private development application for a data center or a warehouse, that's gonna require municipal site plan approval. So it's not effective.
Okay.
This is only for things that, for whatever reason, don't require municipal approval.
Well, you were talking though about a tower, a private tower on a municipal
Right.
lot, that would, doesn't require review at the local level.
No, it's a municipal property.
They have a contract, they might have a developer's agreement, but they do not actually issue like a building permit. They don't issue anything that says, we've reviewed this for consistency with all of our standards. It's interesting. It doesn't happen often. I can tell you when it does, it causes great consternation here. Is this a private development? Is this a public development? What do we do? So some of this has been uncovered as we've struggled with certain applications that we realized, oh, you're like recycling centers. That was a new one for me.
Right.
This one actually came to light when we sent out notification letters about certificates of filing that are going to expire under the new rule. We got back a response saying, well, we have an existing recycling facility, or we have a certificate of filing that allows us to expand that or construct a new recycling facility accessory to a mine, let's say. We don't need any municipal or county approvals. We don't get that. So what happens now with the certificate of filing? Because the rule says it has a 5-year lifespan unless you get municipal or county approval that the commission signed off on. And then it won't expire. But we don't get those approvals, so now what? So I had never realized that. I mean, there are other approvals, state approvals or the county solid waste management plan, but that's not a development approval. That's not a finding of consistency with wetlands requirements. So they're gap project, who knew? But not, they're not. That's the good part.
But some of them could be major headaches.
Some of them, the pipeline projects were not pleasant. They were difficult for various reasons.
Fine.
Tell me about it.
time has, lessons of the anxiety, but. Yes, some of them are likely to be controversial, and then, in my mind. If there's been no other public process, right, at the local level, then it should happen here. And there should be a formal process, and people should be able to speak directly to the commission. Not just experts and consultants, but neighbors and residents.
Same way it went
and-
at a zoning board or a
Yes.
planning board.
Well,
meeting
it's sort of
that-
the same,
ish.
but not, swearing in of witnesses,
Right,
but
but the
every-
opportunity for the
everybody-
public to hear and provide comment
Right.
and.
in a very open fashion, so that everyone can provide comment and testimony directly to the commission. I think that's very important. And, as you know, when you do this now for the public development project, people get up and speak about the project, and the commissioners can ask questions.
Yep.
And that opportunity would remain, so if you have concerns or questions about somebody's comments, you can ask that to try and clarify, so all of that is established as our process and would continue, and I think it's. Because there is no other public record, there's no other public comment, so I think it's very important
And I think it's
and appropriate.
yeah, absolutely, and it's obviously very smart to keep it aligned with our, as much as possible with our existing process. What people are used to, what people,
Yeah.
recognize as
And I think
the
it's
steps.
good for the public, but it's also, I think, important for the staff and the commission to, do something that's within our, not just within our authority, but within our capability.
Mhm.
We don't, in my mind, we don't want to turn these into, Stacy calls them adjudicatory, formal. Cross-examination, that can happen at OAL, somebody wants to go OAL, they can go to OAL, they can do that. This is, something that's within the commission's ability to do. In a very public fashion, I think it meets the goals that, the court gave us, which is public process and decision by the commission, those are the two keys. And,
These aren't contested case hearings. I mean, the reality is, which is what OAL hears, contested case hearings. These are applications.
Mhm.
And the commission wants to create a factual record that supports its decision. So
Absolutely.
it's a very different need. And this is the appropriate process.
Jessica, did you have any more?
No, I'm glad that we're catching this, it's really important, and I
have my list of amendments.
Oh, this is-
on the top right now.
actually, I was sort of surprised when I read through this CMP that there wasn't, there wasn't a threshold at which residential properties of a great size that would cause a significant impact, doesn't come
Oh,
to the
yeah,
whole
no.
commission.
Yeah.
It doesn't, I was really surprised at that.
Yeah.
Again, I'm just so used to what Florida has been doing with the.
Yeah, no,
Regional
I did that years ago when I was thinking about this gap rule, should we try to
Right.
create something like that, and then I thought.
No,
we
because
need to
it's too
stay in
disparate.
our.
Yeah, it's too disparate. If you only have one classification of projects, you can do it, you can't do it with one. But
Alright, Deb?
All these private developments are building a home, and we're sending them a letter out for a hearing. Are we also letting them know that they have to put a public notice out?
For the
For the
for
hearing.
somebody who's a private project that
Yes,
is got problems essentially, yes, they do have to do notice.
okay, then that'll be in that letter,
Oh, yes,
okay. good,
Oh, yeah.
thanks.
it'll explain we're scheduling a hearing, here's the date, you must do the public notice applicant.
Very good.
Madam Chair, if I may,
Yes, go ahead, Jay.
first of all, I'd like to comment and compliment you for tackling this very difficult project. That's before I get into the weeds. One thing that I have promoted in the past is that we should, as part of our definitions, outline the difference between a transmission line, distribution line, and a service line. And there should be different levels of review for those types of projects. And not only for gas lines, but utility line, water, sewer lines. One of the most difficult things that we've encountered was when we had inadvertent returns at McGuire. And the commission was not even noticed. about those inadvertent returns. And,
I didn't even like that term, Jerry. Inadvertent return, I thought was an obfuscation, but go ahead.
yeah, but that's what they've designed it to be called, so it's
Yeah,
hidden.
yeah.
What is it? I'm sorry.
So with regard to horizontal directional drilling, I'd like to see tightening of our standards. I know that we can't get too deep into this, but there is some data available to give us some guidance as to when we could expect a return. You know, particularly in our sandy soils, it becomes a very difficult matter. And lastly, as I look at commercial development on the expressway or on Garden State Parkway, I'd like to consider how we might be able to handle some of the site plan details that would not be encountered. Not too deep into the weeds, but some sort of standard, because drainage would not be considered. Parking, traffic, just general safety issues should be identified and dealt with, because they're not gonna be dealt with anywhere else.
That is an interesting,
I mean, even,
interesting point.
I'm of the opinion that even if for an application, we have to hire an independent consultant to review that and give us some guidance. At least we would be on firm ground as we proceeding the application.
So, a couple things. One, we do have that ability for any application other than one single family home. I think we can't do it for somebody's just proposing one home. But, for all other applications, we do have the ability, if it's a very complex or difficult application that requires outside expertise or significant review time, to request an escrow
Sure.
and hire, someone to assist us perhaps with issues that we're not all that familiar with, as you're suggesting. But typically, the commission's review would be limited to things that are in the CMP, like stormwater drainage, not traffic.
True.
Right, not parking requirements, but, so there is a little bit of that where we would need to think about,
But if we had an independent consultant review that, that consultant might look at it a little bit broader review than we're entitled to. And I bring this up because if we continue with offshore drilling, there's gonna be, or offshore wind energy, there's gonna be some pipeline, transmission line issues that need to be addressed.
absolutely.
The other thing,
Oh, I was just gonna touch back on the HDD issue. So we had thought about that when we were initially working on this version of the rule. But then the real rule got published. And the real rules covered HDD and addressed some of the issues that commission had identified with HDD and inadvertent releases. So we didn't, oh, thank you. So we didn't include anything about HDD. The recognizing that DEP was already addressing it
Well,
separately.
have they issued a report on that? Well, I
So-
don't know, we're still
so-
waiting. I mean, they
They've
said,
not adopted the rule.
Exactly.
So we're waiting to see what happens.
Well,
They claim they're gonna do it in January, so we'll see.
I guess, as we work through this process, if the DEP does not come up with something, I think we should.
Yes.
Gotcha.
2 years ago, I heard DEP was gonna do something, and I haven't seen anything.
Right, well, we're waiting too. I mean,
I'm sure we are.
they should be right in the thick of preparing the adoption notice and getting ready. That's their schedule, so we'll see.
I mean, you don't need to be a scientist to know sand is a problem, pressure is a problem, pipe size is a problem, depth of pipeline is a problem.
Certainly, Jerry, I'm not familiar with the technical aspects of, particularly my memory just deleted that portion of the real world. But it does, previously, DEP didn't look at HED, and the rule will now require them to look at HED as part of their permitting process, make sure that there's a plan
For wetlands,
for wetlands.
Right, so well.
Wetlands, coastal, I
yeah.
think,
So it's gonna require more review
More
for GPs or IPs or whatever people need for HPD, right? Which will be helpful to us. I don't know if it'll be sufficient, but at least it's.
and it requires notice of, returns, and it requires an emergency or contingency plan. So a lot of what we put into play with regard to pipelines, DEP has incorporated into that rule, but you're correct, we're still waiting for the adoption.
I
Keeping an eye.
bring it up, I'll keep an eye on it, and like to make sure that we
Good point, yeah. Thank you.
work on it. Thank you.
All
Madam
right,
Chair?
yeah, go ahead, Mark.
Thank you. I'd just like to say that I support what Commissioner Irick, off, support what Commissioner Irick is saying, and obviously that it's not on the table before us today, but we do need to be mindful of it. And frankly, now that the real rules have been pushed back to January, that means that whatever the new administration is coming in is going to be the one to deal with this. We have no idea how they may feel.
No, Mark, I mean, I'm not an expert on DEP's process, but from what I understand, the commissioner, their goal is for the commissioner to be signing the rule adoption in December or the first week of January, which is prior to any new administration.
Okay.
That's
Okay.
my understanding. I don't know where they are right now in terms of being able to, that was the goal.
Yeah, well, and of course, that's really a side issue to the discussion here, but I just want to be clear. I think Commissioner Eric's right. It's HDD. It deserves further attention, especially if the real world doesn't go through. But as for what's in front of us today, I think gap application is a great name for this, because there's several different ways that an application can fail to get CMP review on a local level before coming to us, or fail to get opportunity for public input into the project before it gets to us. So it makes sense. That's a good coverall name. And I think what you've done really addresses what the Superior Court was asking us to do. You've covered the bases. I just have one question about it. You've outlined 8 steps in the gap application process, but there was one other step that was an optional step that was alluded to in the presentation, and that was the one about if a substantial issue of public interest is presented, then a public hearing could be offered. And I wonder if we've included enough language here, or if we have other language elsewhere in the CMP that describes how do you determine that a substantial issue is presented that warrants a public hearing? Do we have an objective way to evaluate that the public can see and rely on, and know that they'll get their shot at a public hearing if it's really warranted?
Right, so just to be very clear, that public hearing process occurs for private development applications.
Yeah.
Not gap applications, but private development applications that receive municipal or county approval. So it's when the staff reviews the municipal or county approval that determination of whether a substantial issue is raised comes into play. And there's so many different standards that have to be reviewed that I think it would be difficult to try. That's all the CMP says is, does it raise a substantial issue, or doesn't raises only no substantial issues? There's no matrix, there's no detail in the rules themselves about what that is. So it does involve some level of subjectivity on the part of the staff. But it's not laid out specifically in the rule. I mean, you would have to have. I can't even imagine how we would go about doing that. It would need to be, if it's a stormwater management issue, there's so many different stormwater management requirements that have to be met. So it's really a decision about what point is the stormwater plan that's being provided, just inconsistent with the CMP. That's how I'll say it. There are some minor things that are okay. But yeah, I'm struggling a little bit. It's not something that you could point to in the rule and say, if an application does this, that's a no substantial issue. Because
Mhm.
really all the rules say is you must be consistent with CFP.
Yeah.
And only these very minor little variations or peculiar circumstances where the staff has, they would really consider saying, oh, okay, no substantial issue. It doesn't, I don't think it comes into play very often, honestly.
Mhm.
I think your concern is actually addressed by the current proposal, because
Uh-huh.
the still hasn't, it's going, these gap applications are gonna be treated as a public application. So the public has the opportunity to comment at a commission. If it's something that's very controversial, it would certainly be up to the commission whether or not it wanted to hear some matter over many meetings or extend the comment period. But it's the same process we follow now with regard to publics. So there is public input and both written and to end, the opportunity to speak on the record. So I do think your concern is addressed.
Okay.
We'll just have to see, how the applications go.
And there'll be a report from the staff, it's like there are for public development projects now that identify. All the relevant CMP standards and whether the application is, in our minds, consistent with those. And there'll be a notation in those reports if there's anything unusual or different that needs to be taken into consideration. Because of the nature of the project or the location of it, if there's anything that maybe is not strictly consistent with the CMP, but that would fall into that sort of no substantial issue determination. That'll be in the report and a decision that's made by the commission for these projects, so I think that all of that it'll be very clear in the report and to the public and to the commissioners themselves if we're encountering one of those substantial or no substantial issue situations. That'll be a finding and that's made by the commission itself.
Mhm.
For these projects.
Okay, all right. I appreciate your thoughts on that. Thank you.
Alright, any other comments on this? Alright. Thank you very much. Next up is public comment. Mark, you can put the number on the screen. Mark on the next.
I'm not doing that.
Nope.
You're too old.
Thank you. Okay, first up is Robin. Jen.
Sorry.
Don't hurt the public.
Especially well.
Hi, everyone. Robin Jenny with New Jersey Conservation Foundation. Very delighted to be in this space with you all. Quickly, I will just start out by saying, in response to Commissioner Rittler Sanchez's question prior to closed session about why so few applications maybe have come into the Conservation Fund in the recent past. I thought that all of the speculative answers were spot on, frankly. And the match really is a challenging problem. Green Acres will match 50% of a project value and the commission will do up to 33%. But finding that last bit really can be a challenge. And I just wanted to add that a long time private foundation that was often a really good source of match went away about a year or two ago. And I think that really impacted a lot of land preservation opportunities. So just wanted to put that out there. And it's a good segue because although I'm very sorry that you have not had many applications, I'm deeply grateful for the staff's consideration, recommendations, and the commissioner's allocation of $3 million to a very, very exciting and important project. The landowner has been very open and public about their intention to conserve this property. So I won't go into specifics, but I will say that this allocation truly is an important catalyst to moving forward and gaining additional funding to have this base of support to start from. I'm very, very optimistic. I feel really positive that this is gonna happen. Partly because the landowner was motivated due to the commission's recent rule proposal that, sort of really up to the ante to get conservation done. So thank you for that. And I cannot help but, add on a personal note, it's been over 6 years since I have been here with all of you on the other side of the table, and possibly 10 years since I thought I might get to work on the rule proposal myself here. So it's really a very full circle moment, and to have the opportunity to conserve the entire property, even beyond the potential significant reduction in development opportunity, is just so meaningful. I feel truly grateful to have the opportunity to work on this with all of you and a number of amazing partners, because this certainly is going to be a large partnership effort. And I will just close with saying that we are on a fairly expedited timeline to get this done. So the timeline for the grant agreement that was stated should be no problem, and we will be actively working to get under contract as quickly as possible and continue to secure additional funding. So much gratitude for the allocation and the support, and look forward to sharing updates and working with you further. So thank you.
Thanks so much, Robin. Stephen Elliott.
Morning, commissioners and staff. I just want to echo Robin's comments on behalf of the Pinelands Lions and the Friends of the Black Run Preserve. This is a real great step forward. Acquisition of the headwaters of the Black Run seems to be a real possibility now, and that's a lot of thanks go out to the commission for their work. We also want to thank you for doing the work on these gap applications. We do have a quick question whether water allocation would be in there. I know it was on one of the slides, but if is there a certain limit or where water allocation would come into play with those applications? Because we know we ran into that with the Pinelands golf course down there. But thank you again.
Thank you. Oh, yeah, Gina can address that.
So the commission doesn't actually regulate water allocation. We do, however, evaluate the impact of diversion greater than 50,000 gallons per day on wetlands, and to the extent that any application for a new well is meeting that threshold of 50,000 gallons per day, we would review it, and I do think for the most part, those fall under the GAP rule.
All right, thanks, Gina. Anybody on the line? Oh.
There are no callers.
All right, I'm shutting it down. Any final comments from any commissioners before we move to adjourn?
Happy Halloween.
Yes, awesome. All right, can I get a motion and a second to adjourn?
So moved.
All right, all in favor?
Aye.
Aye.
Opposed, abstentions, thanks, have a great Halloween and a great weekend.